interesting case. Opening arguments at the Supreme Court today for one of those big cases in the digital age with national implications for all of us. Here's the question. Should the government, or police more specifically, be allowed to search your cell phone location data without a warrant? Or does that violate the Fourth Amendment against unreasonable searches and seizures? It's called the Carpenter case. It starts in the Midwest, where a man named Timothy Carpenter and his half-brother were convicted of armed robberies of stores. They were stealing cell phones in Michigan and Ohio. Well, the government had evidence that Carpenter made cell phone calls near each of the 9 armed robberies, and they convicted him using his cell phone location data.
So now this goes to the Supreme Court. Joining us to discuss this case, BC law professor Robert Bloom. Thank you so much for coming in.
My pleasure, Liam.
Carpenter was convicted. He appealed to the Court of Appeals. They said the Fourth Amendment does not yet extend to cell phone data, and they're basically asking the Supreme Court to rule on that question.
It's a very interesting case because the Fourth Amendment, which protects an individual privacy against the powers of government, was written in 1791. So I'm sure they had no idea that this was going to happen. So the court has to address how do you make the Fourth Amendment relevant to today's digital age, and that's the interesting thing about this case.
That's the crux of the matter, because
Absolutely.
The interesting thing here about whether or not someone has privacy is what's called third-party doctrine. That Are you giving up your right to privacy by giving your information to a cell phone company, and should the government just be able to access that, right?
The third-party doctrine started in 1979 in this case in which the government got a pen register. So for those of us that are somewhat older, we remember getting phone bills that had the numbers that we dialed. And that's all they got initially. And by giving it to the phone company, you know the phone company was going to get that data. But cell phones are almost an appendage of your person. Everybody has a cell phone. It's not like you can live in this society without a cell phone. I could, but most people couldn't. So it's really an important kind of thing.
So it's almost like the government can follow you around physically.
The government can follow you around.
That is the notion here that is in question, because they didn't get a search warrant for these cell phone data, the location data. Lawyers for the police here say, well, we didn't look at the content of his phone calls or his text messages. We didn't look at his emails. We just looked at where he was placing phone calls. Therefore, that's within the third-party doctrine. We didn't need a search warrant. Do you think they needed a search warrant?
It's not as though the police can't do it. It's just that they should have had some justification, probable cause, I would suggest, not reasonable suspicion, and get a warrant. So that and learning about where somebody's been over an extended period of time, you can learn a lot about an individual person, where one worships, what restaurants they go to, what banks they go to. So you can learn a great deal of information about an individual.
How do you think the Supreme Court is likely to rule here? Because, as Liam said, there were old rules, right, about a letter, that if someone sees someone's letter, they could see the return address, obviously, on the outside, but couldn't read the content. How do you think they'll rule?
In 2014, they ruled on a case involving a cell phone with regard to a search incident to an arrest. So I think they're sensitive to this issue. And my best guess is they're going to say that it's going to require probable cause and a warrant. That doesn't mean the police can't get it. They just got to show some justification to a judge.
In this case, they did not. We're expecting that ruling in June. We will see how it goes. BC law professor Robert Bloom, thank you so much for coming in.
My pleasure. My pleasure.
Thank you so much, Dave.